Hi, it's Nathan here, and today we're talking about sections 13 through 18 of the Model WHS Act. So these are principles that apply to duties. So all of the WHS Act and all of the WHS regulations impose these legal duties on different parties, and these sections, section 13 through 18, are principles that apply to those duties. So the first one is a duty is non-transferable, and that's really important because imagine if you hired a bunch of people, it would be very easy for you to just go, well, you know what, I'm just going to hire a company that will kind of sit in between us, and I'll transfer the legal duty of ensuring the safety of all those workers to this other party. And in that case, you would just have a bunch of shell companies set up that inherit all that legal duty, all those legal duties. And then when a worker gets injured, the parent company would say, hey, no, we transferred the duty over to this company, and then that company would just disappear. So it would open up the door to all sorts of shenanigans in terms of being able to avoid duties. So duties are non-transferable. The next one is fairly simple. That is, a person can have more than one duty. That's fairly straightforward. A PCBU will have hundreds of duties potentially. The next one's a little bit tricky to understand, but it's a duty can be shared by more than one person, or more than one person can have the same duty concurrently. So the most common situation when we have that is where you've got like principal contractor, subcontractor, worker. So the principal contractor and the subcontractor have a shared duty to take care of that worker. And then what it says for that is, I could make a whole video on this one. I probably will make a whole video on this one, but it basically means you need to discharge your duty to the extent that you have influence and control over that situation. So the more influence and control you have over that situation, the more you need to discharge that duty, or the more responsibility you have. It then goes on to talk about management of risks. So under the Act and the regs, a lot of these duties are around managing risk, and then it says that for those duties, the duty is to eliminate, as far as you possibly can, eliminate risks to health and safety. And if you can't do that, then minimize. You need to minimize the risks to health and safety. And then section 18 has a definition of what is reasonably practicable. So I hate that word. I really wish they just said what's reasonable or something, because it's a real tongue twister and very confusing for everyone to understand. But the term reasonably practicable is used again and again and again in the regulations. So it doesn't say you need to manage this risk. It says you need to manage this risk as far as is reasonably practicable. And then it gives like a bit of a definition for that duty. And it says that when considering what is reasonably practicable, you need to look at the likelihood. So if something's very likely to happen, then obviously then you have more of a duty to manage that risk. So the example I give is, what are the chances, or what's the likelihood of a plane crashing on your workplace? It could happen. Somewhere in the world today that will happen, but it's not very likely. So you don't really have a duty to manage that particular risk. The next is a consequence. So we need to take into consideration the consequence or the degree of harm from the risk. So the example I give there is a paper cut. We could all get a paper cut. There's paper everywhere. Is it reasonable for the workplace to go and ban all paper? Probably not. Next is what the person knows, or what the person ought know about the hazard and ways of mitigating the hazard. So the example I give there is, nowadays we all know about asbestos. We all know it's a hazard. If you're breathing in asbestos, there's a good chance you're going to end up with silicosis or mesothelioma or asbestosis or whatever. And 200 years ago, 300 years ago, 500 years ago, I know the Act wouldn't have existed back then, but hypothetically, we didn't know about asbestos. So what can you expect business owners to do about hazards that we don't really know about yet? Another one is the next one, in determining what is reasonably practicable, is the availability and suitabilities of ways to minimize the harm. So if there's no ways that we as a civilization or as a country actually know to manage that risk, then there's nothing, that duty doesn't really apply, or you can't really enforce that duty very strictly. So for example, driving cars around the place, we can make sure the car's serviced, we can make sure the driver is licensed, we can make sure the car is well maintained. But at the end of the day, 1,500 people a year die on Australian roads, and we can't really solve that problem. You've got two chunks of metal you're in a chunk of metal flying along the highway at 100 k's an hour, and there's another chunk of metal flying 100 k's an hour in the other direction with a 2-meter buffer, if you're lucky, between you. There's no suitable way to sort of manage that. And then the last one is the degree of cost involved, and it basically says that when determining what is reasonably practicable, you can take into consideration the cost and whether it is grossly disproportionate to the risk involved. So on that one, it's very hard for the regulator or any court to put a dollar value on someone's life. So if someone's life is at risk, it's very hard to put a dollar value on that. And I've never seen a court case where the defendant has been able to rely upon, oh, well, that was too expensive. Hypothetically, yes, that clause does exist, but I've never seen it used in practice. So yeah, hope that helps. See you next time.